Thank you very much, Igor, and thank you for the invitation again. And as you said, I hope that next time I will manage to be with you. So today I will give kind of a brief presentation, basically about the MLC and the latest amendment that will enter into force in December of this year. Um, hmm. Yeah, so let me start basically by saying that the MLC is a convention of the ILO, because many times, and including here our students, they confuse the MLC with other instruments of the IMO. So the MLC, it's a convention that was developed, let's say, by the ILO, the International Labor Organization, which is the first specialized agency of the UN system, and which has as an objective to promote social justice and internationally recognized human and labor rights. What the ILO basically does, it's basically formulates international labor standards, and not only about maritime, but all labor standards, which sets minimum standards basically in the field of fundamental labor rights. And at the same time provides technical assistance. And when we say technical assistance, it's basically to help and support countries in the implementation of its conventions. The primary goal of the ILO is, as I mentioned before, to promote labor rights and fair labor rights by promoting opportunities for women and men to obtain decent and productive work in conditions of freedom, equity, security, and human dignity. The ILO, and it's really related to the work on the MLC. It's that the work, all the conventions and the instruments that they were developed at the ILO, they are based on a tripartite structure, which is the only, again, UN system that has this, UN agency that has this system. So the tripartite structure include employers, employees, and representatives of government in shaping the policies and the programs. And the objective is to promote a climate of understanding between the employers, employees, and the government, which can take us to the importance of the social dialogue that the ILO is promoting. And by talking about social dialogue, are talking about, of course, negotiation, consultation, and exchange of information between the three parties that I talk about, government, employers, and employers. And all of this to build up kind of a democratic, let's say, decisions by the end, and democratic instruments that include all the parties. Coming now to the ILO and its work on the maritime sector. So the ILO, since its inception, basically, in 1919, has already a very big interest about the conditions of seafarers and all workers basically working at sea, including fishermen. So if we will look just a little bit about what's the work that has been done before the MLC, so we can find that the ILO has done tremendous work on protecting the rights of seafarers. So as an example, one of the first legal instruments that the ILO actually adopted was the National Seamen's Codes recommendations of 1920, so just like 1 year after the inception of the ILO. And from its inception also, the organization has called for the establishment of an international seafarers code, which sets basically the basic or the minimum rights for seafarers, rights and obligations, of course. And then also from its inception, the ILO has consistently addressed all matters concerning the well-being of the seafarers, their occupational health and safety, and dedicated a special sessions known as Maritime sessions in the International Labour Conference. And those are few examples of the instruments that the ILO has developed to protect basically the safety and the health of seafarers. I can mention here the social conditions and safety for seafarers recommendations of 1958, and then the occupational safety and health for dock workers Convention of 1979. It is important here to mention that before the MLC, we had 70 maritime labor instruments, including conventions and recommendations that were developed by the IMO. And then by developing the MLC, all of those conventions, or the best of those conventions and recommendations, were included into the MLC. So if we are talking about almost 70 recommendations and conventions and recommendations that they are touching up the rights of seafarers, so why creating another convention? So basically, there is several reasons why we create or why we develop the MLC 2006. And let's say the first reason, it was that the standards or the instrument that we had have not kept pace with the development of the maritime sector. So we had to have kind of a consolidated instrument that is shaped to be modified based on the development of the shipping or the maritime sector. And then the standards that we had are subject to time-consuming and constantly amendment procedure. So the amendment procedure was so, let's say, complicated, and the time and the cost consuming. The third reason is that the standards that we had lack certain aspects when compared to those of non-tripartite organizations, such as the ones of the IMO. So we had also to have an instrument that include more aspect than what we had. And then because we had a lot of instruments, it was the disparities and overlapping procedures between all the instruments that we had. So those are the main reasons, let's say, why while the maritime community, including the representatives of the seafarers and the ship owners, thought to initiate the development of another instrument. From the beginning, in the 1940 session of the Maritime session of the International Labour Conference, it was a discussion of adopting, as I said, a new instrument, the MLC. And from the beginning, the instrument had 314 votes in favor, and it was none against. And of course, this instrument was kind of a historical step in the maritime sector, and more specifically in the protection of the seafarers' rights. So far, I think we passed 101 or more than 101 countries that ratified this instrument. And basically, it is, as I said, a consolidated instrument that gets basically all the best of the old with a new version. Yeah, and basically we call it also the fourth pillar of the maritime instrument, in addition to MARPOL, SOLAS, and STCW. The instrument, of course, has bring a big change in the landscape of the seafarers' rights. So basically, it brings a new dimension in the protection of the rights of seafarers, and mainly on addressing the fair competition in the maritime industry mostly among stakeholders, by bringing decent employment and social conditions to attract more seafarers and also to retain the ones that we have. And I think we discussed yesterday a little bit about how in some countries the aging of seafarers or the difficulties how to retain seafarers. And then also in terms of the level playing field through no more favorable treatment for ship owners that they are not really respecting the rights of seafarers. So it's basically a kind of a stop shop instrument where we can find everything related to the basic rights of seafarers. The new element that this instrument is bringing is that it's very easily adaptable. So the amendment process is, let's say, not complex at all. The drafts is also very easily understandable, and let's say the main objective also is to give to seafarers the opportunity to understand what are their rights. So the English that is used in the document is very accessible, let's say. And then the attractiveness of to ratify the convention is also an element that it brings. It was brought through this instrument. And finally, it is easily monitored and enforced by having an enforcement title, just to bring this on the top. I will not really, develop more on that. As I mentioned, there is the tripartite consultation system at the ILO, and with this convention, it was the first time that representatives of the seafarers, together with ship owners and the government, they initiated the development of this convention. Of course, this instrument, it doesn't apply to all kind of ships. It applies more specifically to ships publicly or privately owned and ordinarily engaged in commercial activities. And this is kind of precise requirements in the convention. The convention also gives other definitions, like what it is a seafarer. So because there is a lot of disparities about the definition of seafarers, and the convention also bring more precision about the seafarers that they are included under the convention, and the ships. And of course, if there is any doubt, the question shall be determined by the competent authority in each member state. So to summarize about the convention basically and what it covers, so basically the instrument covers the minimum requirements related to the employment and working conditions of seafarers, and it includes the working of hours and rest, the accommodation, the food and catering, health and safety, and social security. So basically, really the minimum right that a worker can have, and here is specifically on board a ship. And then the other elements or the key elements is the certification and compliance. So the obligations for ship owners to ensure the compliance through onboard inspections and certifications. And the third element is the right of seafarers. So the instrument brings a clear stipulations safeguarding the rights of seafarers, including the freedom from discrimination, the right to be part of a union, and the right to a fair treatment. And I think with the COVID, a lot of those last points have raised again about how the seafarers they are treated, and what if those rights are really fulfilled or not. So the instrument has 5 titles, let's say. So the first title is the minimum requirements for seafarers to work on a ship. The second title is conditions of employment. The third one, accommodation, recreational facilities, food and catering. The fourth one, health protection, medical care, welfare, and social protection. And then the fifth one, the fifth title, compliance and enforcement. And this, it's one of the newest, let's say, requirements that the convention brings. And so the structure of the convention is as follows. So we have articles which are mandatory, regulations are mandatories as well. And then we have 2 types of codes, code A, which is standards, mandatory standards, and code B, which are not standard, not mandatory, but they are kind of guidelines that's helping on the application of the convention. As I mentioned before, the ratification procedure is more simple. It's very simple. It follows the procedure that the ILO has on other instruments, and the updates of the convention or the amendment of the convention does not create new revising instruments. So it's just the same instrument that it's usually amended. And this convention also introduces the tacit acceptance as a replacement for the ratification, which was very good. And then the applicable in respect of codes A and B, and of course the tripartite committee, which is a very positive point for the rights of seafarers. The convention has entered into force the 20 August 2013, and as I said, as far as I know for now, we have more than 101 countries that they have ratified the convention, but we still need more. And of course, not only about the ratification, there is also the issue of the implementation, and I think I've seen that tomorrow we'll have we will have another presentation about the issues maybe of the implementation of the convention. Since its inception and development, the MLC has known several amendments during all the years after its entry into force. So the first one was in 2017, the second one 2019, the third one 2020, and the fourth one, it will come in December of this year. The work, it started already on the latest amendments in 2021, and the enforcement will be in December 2024. So let's have a look about the latest amendments. And basically, most of those amendments, they came as a result of all the crises that seafarers they knew during the COVID. and you can see the link. It's really obvious. So I'm given kind of the titles, and then I will develop a little bit. So the first one, it's related the standard A 3.1 regarding accommodation and recreational facilities. The second standard is concerning the food and catering. The third one concerning health and safety protection and accident prevention. And then the fourth one, it touch upon evidence of financial security. So regarding the recruitment and the placement, so basically seafarers should be informed prior to or in the process of their engagement of their rights under the system of financial protection to be established by private recruitment and placement agencies to compensate seafarers for monetary losses. And basically, this is a huge issue because in many cases, actually, the seafarers, when they are signing their contracts, in many cases, they don't really read their contracts. So they are not really aware, even if the convention actually is inviting the placement agencies or let's say the ship owners to provide a very easy, comprehensive contracts, but it's not always the case. And more specifically about the system of financial protection, many of seafarers, they are not really well protected in terms of this. And then of course, during the COVID, it was a lot of discussions about the repatriation of seafarers. A lot of seafarers were blocked, either in the middle of the sea or in some ports that they couldn't even go back home, etc. Then it was a suggestion to amend the convention based on the crisis, basically. And it includes that member states should facilitate the prompt repatriation of abandoned seafarers and cooperate to ensure that those seafarers engage to replace seafarers who have been abandoned in their territory. And then the third point is the accommodation and recreational facilities and access to shore-based welfare facilities. It was during the COVID that seafarers, they had not really proper recreational facilities. But not only that, the problem during the COVID, I think it was that the seafarers, they had not access even to talk to their families. And the problem of the connectivity on board the ship and the problem of internet, it was also raised. So among the amendments of this of the convention now, it will include the access to internet. However, it's not really, in my point of view, it will not really resolve the issue of the access of internet, because even with those amendments, we still ask that, or we still have that ship owners can charge the seafarers, but with a reasonable amount. Why we can charge seafarers? Internet should be accessible to all seafarers, like any one of us working on in offices or anywhere. So anyway, there is some improvement, of course, and it's a good start. There is another amendments that include also the food and catering and the good quality drinking water, because it is an issue, and even the quality of food on board ships for seafarers, it's a huge issue. And when we are talking about good quality of food, we are also including nutritional food. So it's not only to have the minimum to eat, but a seafarer, their job, they are very hard and they need good quality and good nutritional food. So all of those aspects, they were also included: the health and safety protection and accident prevention, medical care on board ship and on shore. So seafarers are promptly disembarked when they are in need of immediate medical care and are given access to medical facilities. And this is also was raised because of the COVID. And then the financial security, which is a really good amendment, and it's a really well needed. However, I'm not really sure if it will be an easy applicable requirements, because I think a lot of, or I mean, some of ship owners, they might not really be able to meet those requirements. So of course, all of those amendments, they bring some positive and some challenges, let's say. So for the seafarers, it's improved, of course, their working conditions. The amendments contribute to a healthier and safe working environment and promoting the overall well-being of their well-being. And then it strengthens their rights, so it's emphasized on social security and access to medical care can provide critical safety nets for seafarers who may experience workplace-related challenges. But as I mentioned, there is also the compliance concerning the cost. So it might increase the standards that might lead to higher operational costs for ship owners, which is might not really be appreciated. And then it's enhanced at the same time, it can enhance the reputation of seafarers if they will comply to those requirements. Those ship owners, sorry, might have their reputation enhanced, which can help also to fostering a positive corporate image, and that seafarers also would like to work with them. And overall, all of those improvements, let's say, might help also on the improvement of the image that we have on the maritime, about the maritime sector, and especially about, to change the image that we have about it, and especially when, seafarers, they face a lot of challenges during the COVID. But this is not really the only thing. There is, of course, a lot of challenges concerning the compliance and the enforcement. So I can mention here that's regarding the diverse regulatory framework, because even if we amend the convention, a lot of effort should be done by the member states. And of course, it's all relies on the flag state to enforce these provisions. However, member states have different interpretations and implementations of the convention that might lead to inconsistencies in compliance and enforcement into their jurisdictions. And then, of course, the resource limitations whatsoever, if the ship owners would like to do that or not, there is a lot of costs that they are involved on that. And then the port state control variability, the effectiveness of the port state control in enforcing the MLC in general, and not only regarding the amendments, can vary widely among ports, so potentially leading to disparities in compliance and protections of seafarers. So saying that, the amendment, they are bringing very positive steps, but the issue might be in the implementation, of course, and how all the stakeholders can manage actually to work together to try to come up with solutions, even if we can see some that they are already in place, like even for the access of internet, there is a Starlink, for instance. Now there is some technology providers that they are helping out, let's say, and working together with ship owners. So there is some steps that they are going forward, but we might need more work. Those are basically it was just suggestions, what you can see now in the slides. I've been part of some meetings with ITF, and basically it was a document that was in addition to this amendment that I just show you. Um, we had some suggestions to the ILO to add, or maybe for further work, maybe in the future, regarding the issues that we know now at at the maritime sector, including the working hours and rest hours. And why I said the WMU, because one of our work here at WMU is that we publish a report about working hours and the fatigue of seafarers, and it was included also into this discussion about the working hours and rest hours. And this is just kind of, I took a snapshot of what was suggested to the ILO. So for instance, here, regarding the minimum hours of rest should not be less than 96 hours in any 7-day period. And this is really was based on a study that we have done here at WMU. Another point that was also suggested to the ILO, but again, it's just a suggestion. It wasn't taken into account yet. So maybe the ILO will come back to it later on. So now there is a lot of discussions, of course, about the harassment, the violence and the harassment, including sexual harassment, bullying and sexual assault in the maritime sector among seafarers. And also we suggested some amendments. So, and here you can see some of the amendments that we provide in terms of the text. I mean, I can mention here, for instance, for the standard A 4.3, health and safety protection and accident prevention, we suggest to add a new paragraph that includes in measures to eliminate violence and harassment, including sexual harassment, bullying, and sexual assault, in accordance with the Convention 190, Violence Harassment Convention of 2019, and so on. So we suggested some additional, let's say, text to the guidelines and the standards, but as I said, so far there is no discussions really, formal discussions about it. And of course, there is also some discussions regarding the technology and the mental health that it's resulting from the use of technologies on board ships. To summarize my presentation, I would say that the amendments are, like, the topics of the amendments, they are really very positive and they're very good. But again, the issue of the MLC still the implementation, like a lot of other conventions. So a lot of effort should be done by all stakeholders and including actually the countries that they are providing seafarers. So sometimes they are not really very active into the discussions. So yeah, effort should be include everyone, let's say, and all countries that they are involved in the industry. And thank you.